Constitutional rights of the accused. The United States Constitution sets minimum standards for rights of people accused of crime. And so do the state constitutions. So we get our legal rights of those of us who are accused of crime from both the U.S. and the state constitutions. Now, these rights impact in a very big way what we call criminal procedural law. And of course, procedural law is the how of the law, how we process criminal cases. Let's start with the United States Constitution as it was originally approved. Now, it doesn't have a whole lot to say about criminal procedure and the rights of the accused, but what it does say is so very, very important. In Article 1 of the U.S. Constitution, we have guarantee for what we call the writ of habeas corpus. We have that right to this writ of habeas corpus. And in Latin, that means you have the body. Writ means a court order. And so this is a court order from a court telling whoever is detaining someone to bring that person into court and justify the person's detention. It was so important, it's even been called the Great Writ, and it has its histories in Old English law in the 1400s, and perhaps even before then. And as I said, it allows a court to determine the legality of a detention, and it has several applications in criminal law. First of all, what if no charges are filed? How does a person get free from court, from detention, from the jail? Well, they go into court, or their advocate goes into court and files a writ of habeas corpus. It's also used to challenge the amount of a bond when someone is arrested and a bond is ordered to guarantee their appearance, but it's a very, very high amount of money. The writ of habeas corpus can be used to challenge that. But also if it's a no bond situation, and they're saying that at least I should be given an opportunity to post some sort of a bond. And then also, writ of habeas corpus is used to challenge the validity of a conviction. Now, the Article 1 of the Constitution also mentions a couple other things that are very important. First of all, it says there will be no bill of attainder. What's a bill of attainder? Well, it's a legislative act declaring someone guilty of a crime and setting a punishment for it. You don't see that a whole lot, but occasionally someone will challenge a legislative act as actually being not regulatory, but a bill of attainder against them. And what you'll see more often, though, is what we call the ex post facto law. And these are also prohibited by the Constitution. Ex post facto law is simply, it's a retroactive criminal law. So that would be like you go to a class and one day and the police walk in and say, oh, by the way, city council changed the speed limit last night around campus, and we came to give all of y'all a ticket for how fast you were driving yesterday morning. Well, that's an ex post facto law, and that's unconstitutional. Now let's look at the amendments to the Constitution. As I said, the Constitution as it was originally adopted did not have a whole lot to say about criminal procedure and criminal rights, but the amendments do, particularly the what we call the Bill of Rights, and especially the first 8 amendments. Let's look at the Fourth Amendment. The Fourth Amendment has a prohibition against unreasonable searches and seizures. Well, what is an unreasonable search and seizure? Well, we have a general rule here that says if you have a warrantless search, a search without a warrant, well, that's going to be unreasonable unless, and there's a lot of unlesses, a number of exceptions to that general rule. And things like, well, if something is in plain sight, officer doesn't have to have a warrant to be able to seize it if it's in plain sight. officer doesn't have to have a search warrant to search someone he has arrested to protect himself and others in the event that person has been arrested has weapons or contraband on them. So incident to arrest, plain sight, and a number of other exceptions exist to the idea that you have to have a warrant to have a reasonable search. But what are the requirements for a warrant? The Fourth Amendment to the Constitution says that warrants must be supported by probable cause. And that probable cause has to be supported by or sworn to under oath. And the search warrant that does come from this does have to describe the person or to be searched or seized and the place to be searched or seized with particularity. Now, if evidence is seized illegally in violation of the Fourth Amendment, then we have a very, very important rule that comes down from the courts called the exclusionary rule. And it simply says that if evidence is seized illegally in violation of the Constitution, then that evidence cannot be used. It must be excluded. And the way a defense attorney would typically challenge that evidence would be to file a motion to suppress the evidence. And there would be a hearing, and then the judge would have to decide whether the Constitution was violated in the collection of that evidence. The Fifth Amendment has a number of things in it. First of all, the Fifth Amendment to the Constitution says you got to have a grand jury indictment, which is called a true bill. And that's for serious offenses. Those proceedings are closed, and those proceedings are generally guided by the prosecutor. And if the grand jury votes a no bill, that means there's no indictment. Fifth Amendment also says no double jeopardy. That means you can't be tried twice for the same offense. But of course, that does not apply to an appeal, successful appeal, and the trial following that, and it doesn't apply to when the state and the federal government both prosecute for the same offense, like robbing a bank, using both the state law and the federal law. Self-incrimination is prohibited under the Fifth Amendment. You can't be compelled to testify against yourself. You've heard of people taking the fifth. That's what that means. Fingerprints and blood, when that's taken as evidence, that's not self-incrimination testimony. That's not counted as testimony, so that doesn't apply. Fifth Amendment also says you can't be denied due process of law. Cannot be denied due process of law. That basically means a fair procedure. And if any of these things are violated by the government, once again, the exclusionary rule does apply. The Sixth Amendment. Sixth Amendment has a lot about criminal procedure. It says a person accused of crime has a right to a speedy trial, a public trial, an impartial jury. Person also has a right to be informed of the charges against them. Also to be able to confront witnesses. There's no secret trials without witnesses coming forward. This gives the defendant a chance to cross-examine the accusers. Defendant has a right to compulsory process. That means if they're favorable witnesses for the defendant has a way to force those people through the subpoena to force them into court to testify on behalf of the defendant. And then the Sixth Amendment also guarantees the right to assistance of counsel. And then we have two more. The Eighth Amendment. The Eighth Amendment is very short, and it says simply, excessive bail is prohibited. You can't have a bail that's unreasonable, set too high. And as I said earlier, the way you challenge that is through the writ of habeas corpus. And the Eighth Amendment also prohibits cruel and unusual punishment. Now, what may be cruel 100 years in our history what wasn't cruel 100 years in our history ago may in fact be cruel now. It's a standard that develops and is relative with time. But nevertheless, a very, very important protection to people accused of and convicted of crime. Then we have the 14th Amendment. 14th Amendment was passed by Congress following the Civil War, and it was adopted by the states after that time. It says that states may not, and it says several things. One thing I don't have on the board is can't deny privileges and immunities of rights of citizens to citizens of the states. But more importantly, with criminal law, it says you can't deny due process of law. Well, we've already seen that part in the original part of the Constitution, but now this is saying the states cannot deny due process of law. And the 14th Amendment says the states have to, or rather cannot deny equal protection of the laws to their citizens. So the 14th Amendment applies to the states. Now let's talk about the incorporation doctrine here. What is the incorporation doctrine? Well, you have to start off with this bottom comment I have right here, that the Bill of Rights was originally applying only to the federal government and not the states. And so if there were going to be any criminal rights for, any rights for those criminally accused, those would be coming from the state constitution. But then gradually over time, the federal courts developed this process called the incorporation doctrine, whereby parts of the Bill of Rights that formerly applied only to the federal government would now be made applicable to the state government. And they make that is incorporated, made part of the 14th Amendment, because once again, the 14th Amendment says states may not deny due process of law. And so for an example, well, wouldn't having assistance counsel be due process of law? And the courts have said yes, in the case of Gideon versus Wainwright. So very, very important doctrine. Now, not all things in the Bill of Rights have been applied to the states, like grand jury indictment has not been applied to the states. Some states have a system of initiating criminal charges that does not include a grand jury indictment. Most do, but in any event, that part of the Bill of Rights has not been made a requirement of the states through the 14th Amendment. And that's an overview of constitutional rights of the accused.